It's on.
Good evening. I'm Seth Lon. It's my honor to serve as faculty advisor to the Sherman Minton Moot Court competition, and it's my honor to, on behalf of Dean Austen Parrish and the law school, welcome you to the Sherman Minton Moot Court finals in this, the 50th anniversary year of the Sherman Minton competition. The competition is named for Indiana's only Supreme Court Justice, Maurer Law School's own Justice Sherman Minton, class of 1915. Justice Minton, who was appointed to the Supreme Court by President Truman, served on the court for a relatively short period, but in that time took part in many important decisions, including the Youngstown Steel decision and the court's decision in Brown versus Board of Education. As Justice Minton looks down on us from the back of the courtroom tonight, I like to think that he would be pleased by the things that you're going to see exemplified by tonight's advocates, I think, which is commitment to rule of law, scholarship, reasoned discourse, and commitment to constitutional values. A competition of this complexity and duration requires the efforts of hundreds of people, many of whom you're going to meet or hear recognized tonight. But before we do that, I'd just like to take a moment to first thank all of you, first of all, the other competitors in the competition whose uniformly high level of effort and expertise really made it I think, historically great competition this year, and many of whom I'm very happy to see are here to support their classmates who are arguing tonight. And then all of you, the families and friends and other classmates of the competitors who have been supporting them throughout the last few months and really made that high level of competition and effort possible. So thanks to all of you. It's been a particular pleasure to work this year with a really wonderful moot court board, and I personally would like to take a moment to thank them, and as their representative, thank in particular Lauren Hodge, the Chief Justice of the Sherman Minton Advocacy Board, and it's my pleasure now to introduce you to her, and she will take over from there. So thanks again, and enjoy tonight's arguments.
Thank you, Professor Lon. Good evening, everybody, or more like good afternoon. Thank you all for being here. So for most of you, you realize how this competition works, but there are others who don't. So briefly, we want to just run over what exactly happened. We started the field with 151 competitors. 151, vast majority, 2Ls, who competed this year, making it over 75% of that 2L class. So overwhelmingly, the majority choice activity. We had them write briefs in pairs, and then these briefs were graded by our own competition board, and then we went through, and there were 3 rounds of oral arguments. The field was then narrowed from 151 competitors to 32. Our top 32 octo finalists are represented here today, and with them, we want to take a moment and say congratulations and thank you for the wonderful, wonderful rounds that we had. They represent the top 20% of the Sherman Minton Moot Court experience here. So if you would please rise when I say your name, and then if we could just hold applause to the end. So for octo finalists, Sarah Bauer, Jarrett Bauman, Emma Gormley, Benjamin Hoffman, Skylar Hudo, Adam Cornia, Jasmine Lewis, Lexi Muir, Melissa Orizondo, Derek Raymond, Alex Robbins, Hillary Shepard, Nicholas Taylor, Sloan Thacker, Andrew Thompson. Quarterfinalists, Melanie Broom, Jinwoo Choi, Katie Cullum, Ashley Eklund, Eric Jones, Onika Metsika, Lindsay Potterfield, Landon Rookard. Semifinalists, Megan Binder, Nikki Hewell, Daniel Matheny, Drew Waldbesser. If you would please join me in giving them a congratulations. None of this would have been possible without our wonderful competition board, who put in over 800 hours of brief grading, over 375 hours of oral argument, who acted as mentors, as peers, and as confidants for our competitors and the 2L class in general. So if you'd please rise, competition board, if we could recognize you, and thank you for your hard work. So tonight you'll hear from the appellant, and we've split up the arguments by issue. So you will hear the appellant argue the Batson issue first, then the appellant argue the First Amendment issue. The appellee will argue the Batson issue, the appellee will argue the First Amendment issue, and then we'll go back to the appellants for rebuttal. So that'll be the format. So they will be arguing in pairs, but there will be issue specific. So then tonight, once we have our competitors, once they come in, we will exhibit proper courtroom decorum. So if you'd please make sure that we keep cell phones off, silence them, and please, respect the competitors who have given so much of their hard time into the competition. We would really appreciate it. In addition to that, what will happen once the competitors walk in, the judges will sit, we'll hear our oral argument. And then at the end, we will rise to give, a round of applause to our well-deserving competitors. But we ask that you allow them to leave the room first so they can get out before the masses. And then after the two arguments happen, there will actually be a reception in the hallway on the first floor with the law school. So we invite you all to join with us there, congratulate our competitors, and mingle with your colleagues. So I'd also like at this time to introduce you to our wonderful problem writers who spent literally months going through and writing and crafting this problem that you all have worked on for so long. So that would be Mr. Michael Deshane and Mr. Trevor Walczewski.
All right, good evening. Thanks for showing up. Trevor and I are really proud to produce this problem, introduce it tonight. We had a great time working with our lovely and talented competition board and advocacy board to develop a problem that shows the intersection between beliefs and vaccination policy in the United States, particularly the state of Saratoga.
Now, our problem is set in the affluent Midwestern town of Lark Valley, a town that bears a striking resemblance to Bloomington. Like many communities around the nation, Lark Valley has been experiencing a rapid decline in the number of students receiving vaccinations over the past decade. And this is a huge problem.
It's a problem because of herd immunity. The theory goes that if a small but significant portion of the population abstains from getting vaccinated, that can lead to risk of epidemic of deadly vaccine-preventable disease that can affect the entire population.
Now, one reason for this decline in vaccinations is the growing presence of a religious community in the Lark Valley area. Just outside the town is a village called New Emden, and New Emden has a high concentration of families that oppose vaccination.
Yeah, New Emden was formed by the Dutch Reformed Church, and in the last decade was taken over by an offshoot of that church, the Restoration Reformed Church. Both of these faiths are united in their doctrinal opposition to childhood vaccination.
One local parent decided it was time to do something about this. Her name is Marcia Pataki.
Now, Marcia Pataki is not just a concerned parent. She's also a high-ranking employee of the school as the wellness coordinator for the entire Lark Valley School District.
That may be so, but if you look at her daily duties, she's more of just a counselor. She meets face-to-face with the students. She certainly doesn't have the power of a superintendent.
not a superintendent, but if you look at the organizational chart, you will see she is only a few steps down from the board itself. In fact, she has to give monthly reports on wellness in the entire school district to the board, who also relies on her for advice on general health policy.
Now, as it just so happens, Ms. Bataki's decision to speak out coincided with a school board election. Specifically, 3 members of the school board were competing against 2 challengers trying to keep their seats. And one of those school board members is Megan Stewart.
Now, years ago, Ms. Stewart wrote on her personal blog about her fears surrounding vaccination and how those fears influenced her decision not to vaccinate her own children.
In the blog, Megan Stewart talks about claiming a religious exemption, but the reason she gives for claiming this exemption seem much more philosophical and ideological than specifically religious. And Ms. Bataki sees this as exploiting a loophole in the district's vaccination policy.
So, Ms. Pataki used the private beliefs of Ms. Stewart as part of an opinion piece she wrote in the Saratoga Star newspaper, attacking the overall policy of the school board, which was liberally granting exemptions to Saratoga's vaccination requirement.
Whoa. You have to look at it in context. So the overall context of this op-ed is just a passionate plea to local parents to vaccinate their students for the good of everyone.
Unfortunately, it was also ripe for political fodder, as challengers for the school board seat formed attack ads like these.
Not everyone in our community cares about this issue as much as I do. As mentioned in a recent opinion article, my opponent, Megan Stewart, has endangered the children of Lark Valley by speaking out against vaccination.
No, Megan Stewart responded with some mudslinging of her own.
Max Brewer believes that I am not working to better my community. He seems to think that my actions are selfish.
As the poll numbers show, after Ms. Pataki released her op-ed, the entire landscape of the election changed. This became a divisive issue that dominated the entire election.
Now, the enraged school board members decided to make a scapegoat out of Marcia Pataki, and they fired her. Ms. Pataki responded by engaging in America's favorite pastime, a lawsuit.
It moved swiftly to trial where more controversy ensued. Attorneys for Ms. Pataki struck 3 jurors based on their membership in the Reformation Reformed Church.
The attorneys were just trying to give Ms. Pataki a fair jury. They were convinced that jurors who had a strong opposition to vaccination would be the kind of jurors who would be highly unlikely to find in Ms. Pataki's favor.
Whether or not it is constitutional to strike jurors on the basis of religion is going to be the first issue we hear competitors tackle tonight.
In our second issue tonight, Ms. Pataki will argue that her First Amendment rights to free speech were violated by her termination.
The school board will argue that they have a right to fire employees and manage employees in their own manner, handle issues in-house according to their mission as educators.
Thank you all so much for coming out. It's been a pleasure to put this problem together, and we're as excited as you are to watch our competitors.
All rise. Oyez, oyez, oyez. All persons having business before the Honorable 14th Circuit Court of the United States are admonished to draw near and give their attentions, for the court is now sitting. God save the United States and this honorable court.
Be seated. Court will come to order. Our first case is Pataki versus Lark Valley School District Board of Education, case number 14-391. Is the appellant ready? Proceed.
May it please the court. I'm Riley Floyd, and I represent the appellant, the Lark Valley School District Board of Education. Juries should not be assembled based on stereotypes, but that's precisely what the district court allowed to happen here, and the district court should be reversed. The district court erred by allowing Ms. Pataki to use her peremptory challenges discriminatorily, and by conducting an improper Batson inquiry, the district court made a legal error. That legal error requires de novo review on appeal. The district court overruled the board's objection to the Batson challenge and said, quote, "I'm not interpreting the Constitution in a novel direction today." That's at page 78 of the record. And it held the Batson hearing literally in the time it took the veneer to return from lunch. The court conducted an improper Batson inquiry because it had ruled on the Batson issue before the hearing ever even took place. That's similar to the blanket denial in U.S. against McMath, a case from the Seventh Circuit, the circuit this court follows for its procedural rules. The well-settled principle that juries should not be assembled based on invidious stereotypes is not a novel one.
Mr. Floyd, what's the invidious stereotype that was that occurred here?
The invidious stereotype that occurred here, Your Honor, is that all three of the jurors that were stricken by Ms. Pataki had somehow had something to do with the RRC faith. And that's the stereotype that we're talking about here. Ms. Pataki will attempt to argue that she struck the jurors based on the fact that those jurors had answered yes to the question of whether an employer may, based on its beliefs, impose an unpopular policy with employees.
Well, I don't understand what's the stereotype? What was it?
The stereotype, Your Honor, is that these jurors would somehow be unable to consider the evidence in this case based on some kind of religious affiliation or belief. And that stereotype is constitutionally infirm under Batson.
If somebody had an antipathy to vaccinations, would that be a basis? If they articulated and said they didn't believe in vaccinations, would that be the basis for a peremptory challenge?
It would be, Your Honor, because...
If that's true, then why does being a religion, why does that inoculate that to make it a no longer satisfactory basis for a peremptory challenge?
It inoculates it,
right?
It inoculates it, Your Honor, because religion, as the Supreme Court held in Friedman against Rogers, is a suspect classification that's entitled to strict scrutiny. And the result of that is, it takes us back to Batson. Batson's central holding was that stereotypes may not be used to select jurors, and that applies to any classification.
But the stereotype wasn't being used here, right? So it's not that they were being, correct me if I'm wrong on the record, but they weren't being excused solely because they were part of the religion. They were being excused because the religion had a belief that was inconsistent with what was on a core issue on the case, right?
Well, Your Honor, we don't have any evidence in the record that they actually adhered to that core belief because the question was never asked. And that's the problem here, because these jurors answered yes to a question during voir dire, and then they were dismissed. And those three jurors, just like all of the other jurors in the veneer, answered that question the same way. The only distinguishing difference between them was that these three jurors were somehow related to the RRC. And that's problematic for the reason that the Second Circuit identified in Brown, where the only distinguishing factor between the jurors that are dismissed and the jurors that are retained is religion or race or gender. Then that means that something has gone awry in the selection process.
So the attorneys glean that they belong to the RRC from what, the questionnaires? from the jury questionnaires, that's how they glean that these people belong to the RRC?
Yes, Your Honor.
Okay, what evidence was in the record of what core beliefs you have when you belong to the RRC?
The evidence in the record, Your Honor, is an editorial that was, or excuse me, not an editorial, a story that appeared in the Saratoga Star that was discussing the traditional beliefs of the members of the RRC.
And that was submitted into evidence?
That was a trial exhibit, yes, Your Honor.
Okay.
It was.
All right, and but in terms of this core belief, there were other jurors that answered the same way, correct?
That's correct, Your Honor.
Okay, and so how many peremptories did the attorneys have?
They had 3.
Okay, and how about the judge's point, though, that, I mean, you can't take them all out, right?
That's correct.
Okay, and so you've taken some out, and there's others that are still in there that still have this core belief, and if your basis is that you're taking them out because you disagree with the core belief, not that you're worried about this stereotype, as you call it, then how is that not a rational explanation?
It's not a rational explanation, Your Honor, because of the fact that that's why Batson exists. It exists for circumstances precisely like this one, where the distinguishing factor for those jurors who were dismissed is a category that's subject to heightened scrutiny. And that's why the Batson analysis...
That's not true here. That's not what Batson says. Batson's referring to immutable characteristics, right? Here, the challenge is based on a belief. That's exactly why you want to use a peremptory challenge, isn't it?
Well, Your Honor, when that belief is protected by the Supreme Court's jurisprudence in the religion cases...
Well, tell me what Batson case, what holds that religion is protected under a Batson peremptory challenge?
3 circuits, Your Honor, have discussed the issue with respect to applying Batson to religion.
But we're not bound by them, and I think the justice's point is that it's not a mutable characteristic, and so why would it be unreasonable to think that if you hold a certain religious belief, why wouldn't you want to adhere to that? Do you want to ask these people to just ignore their religious belief?
And that's the problem, Your Honor, because when trial courts when lawyers are put in the position of having to ask these jurors about their beliefs, that poses a constitutional problem under Lemon against Kurtzman. That's why Batson should apply, because if religion is protected...
You don't have to ask them about their religious beliefs. You just assume that you don't have to ask them. You don't have to go there and ask them. That's the rule that you're advocating for would require us to go into that inquiry, correct?
But the assumption, Your Honor, is constitutionally infirm, because that assumption is then rooted on nothing more than the fact that because this person is a member of this religious group or is somehow associated with this religious group, that person then adheres to the belief. That's the exact reason why the Supreme Court, in a case like Batson, held that those same inferences can't be drawn based on race, because the same argument was attempted there, that if a juror is a member of one race or the other, then that juror will automatically come into the veneer process with a certain inclination toward an outcome. And that's problematic.
So you don't see any basis to draw a distinction between the immutability and the non-immutability?
Well, Your Honor, as I mentioned a moment ago, the 3 circuits that have addressed this issue have attempted to draw a line between religious affiliation and through belief. But both are equally constitutionally infirm, because a line between affiliation and belief can't be drawn. The Seventh Circuit addressed this problem in a case called U.S. against Herron, and the Seventh Circuit held that attempting to draw that line is untenable.
Let me ask you this question. I have a capital murder case. Person's part of religion, very clear. They put it on their voir dire form that indicates they're against capital punishment. Can I use a peremptory challenge there?
You could use the peremptory challenge there, Your Honor, because...
It's the exact same thing. They're going to say that the only information I have there is they're part of the religion. I've just violated your Batson. I've got a prima facie case of discrimination, right?
If you're basing the strike, this gets to the issue of how the Batson challenge is addressed in the trial court. If the Batson issue is raised and the objection is made on the basis of religion, that's a different analysis, because then that should trigger the Batson question. Here, in all of the 3 other cases before those 3 circuits I mentioned, the Batson objection was lodged based on race, and that's what gave those courts room to hold differently than the ruling that we're advocating for here.
Counselor, then where do we draw the line with beliefs? Suppose that on a jury you have a member of the NRA who will argue that there is a Second Amendment protection as to their beliefs. You're trying a case which involves gun ownership or gun usage. So now are we going to apply Batson to that as well?
No, Your Honor, and that's where the line can firmly be drawn, because the problem there, that belief is not protected by any of the Supreme Court's jurisprudence with respect to religion. The belief of someone who associates themselves with the NRA is not entitled to strict scrutiny, and so there would be no heightened analysis there as there would be here.
But why shouldn't the standard be that to prove a prima facie case, you have to show that the basis of the challenge was based on the religion rather than the belief that's part of the religion? And if that's true, where in the record shows here that the basis of the challenge was based on the religion rather than the underlying knowledge that the religious faith had a belief?
Well, here, Your Honor, and that's why we submit that at the very least this court should remand for an evidentiary hearing, because it's not at all clear from the district court whether we don't have a clear factual record with discrete factual findings with respect to why these 3 jurors were dismissed. And that's why there's a problem here on this record, because we know—
The problem, though, for you, I guess I'm suggesting that you failed to make a prima facie case, because the record seems to suggest that the basis of the challenge was based on the underlying belief, not on the religion itself. It just happened to be that there was correlation between the religion and the belief.
There was no evidence of a belief, Your Honor, because the exhibit that I mentioned earlier in response to Judge Babb's question, that was introduced as a trial exhibit. It wasn't introduced, to my knowledge, during the voir dire process. So when these jurors were being questioned during voir dire, the information that was being used to exclude or include them on the jury was harvested from the juror questionnaires. And the only evidence available and evident from those questionnaires was that these jurors lived in New Emden, which is a village of about 8,000 RRC members, that juror number 8 is the foreman of the Community Supported Agricultural Initiative, a farm founded by the RRC, and juror number 15 is an active church member and moved to New Emden to be a part of a like-minded community. Likewise, juror number 10 said that he likes to attend church events and socials. All of these facts became proxies for juror competence and impartiality, something the Supreme Court explicitly forbade in JEB against Alabama.
Well, let me ask you a question. You raised the JEB case, and there's an interesting statement in that, and I wrote it down. And this is from the majority opinion. It said, even strikes based on characteristics that are disproportionately associated with one gender, and again, of course, that case was about gender, could be appropriate, absent a showing of pretext. And isn't that exactly what we have here? There is, of course, a likelihood that a disproportionate number of the RRC members do not believe in vaccinating children. So why was that not, even under JEB, an appropriate proxy?
Because here, Your Honor, Ms. Pataki's lawyers did not even— I see that I'm out of time. May I conclude?
Yes, please.
Ms. Pataki's lawyers did not even offer a neutral explanation. When the Batson challenge was lodged, they only said they were trying to, quote, get the best jury they could. That's at page 77 of the record. That's not a neutral explanation like the one required under JEB, and that's why this court should reverse the judgment of the district court. Thank you.
But then who provided the explanation, the judge?
Well, Your Honor, at the Batson hearing, then Ms. Pataki's lawyers said that each juror answered yes to the question of whether an employer could institute a policy, despite that policy being unpopular with some jurors. But the problem with that explanation was that it wasn't lodged at the outset. It was lodged once the Batson hearing began. And so that suggests that Ms. Pataki's lawyers needed time to come up with that explanation.
Let me ask you, let's say it's remanded, right, as you want us to do, right?
Yes, Your Honor.
It goes back, the lawyers stand up and say, why did you get rid of them? Well, because I thought they didn't think they liked vaccinations.
Yeah.
We're done, right?
No, Your Honor, because as I—
You said it was lodged later, so they have the belief now. So what other additional evidence is going to be offered on the remand that is going to allow the court to conclude that there was either religion discrimination as the basis of the challenge or not at this time?
Because, Your Honor, then that triggers the third component of the Batson analysis. And this comes from Johnson against California, a 2005 case from the court, which said that if the explanation is neutral, the court then must decide whether the opponent of the strike proved discrimination. So you've identified the second component, but the court, on remand, would still have to deal with that third component.
Yeah, but as a matter of law, and I guess that's what I was pushing on earlier, can't we say that there's no way you can prove discrimination on the record here on the basis of religion? There's nothing there. So I guess I'm saying it may be ambiguous, but what do you point to in the record to show that the basis was religion rather than, as the Chief Justice was saying, the logical explanation of the basis of the belief rather than the religion itself?
We submit, Your Honor, that the 4 facts that we identified earlier, the 3 stricken jurors living in New Emden, the fact that juror number 8 was a CSA foreman, the fact that juror number 15 was an active church member, and the fact that juror number 10 likes to attend church events and social events, that those facts became proxies for this religious issue. That's what we submit here. Thank you.
Thank you.
Thank you.
In Pickering v. Board of Education, the Supreme Court acknowledged that a free and uninhibited debate is a core value of the Free Speech Clause of the First Amendment. But just as we limit what people can say in the form of threatening words or fire in a crowded theater, so too we limit what a public employee can say. As the Supreme Court noted in Garcetti, this limitation is important so that we can provide efficient public services, such as public education in this case. In this case, the lower court erred when it ruled that as a matter of law, Pataki was not a policymaker. To the contrary, she is a policymaker, and under the Rose exception, this favors the government as a matter of law.
A wellness coordinator is a policymaker?
Yes, Your Honor.
How?
The wellness coordinator is the point person in this school district for all things wellness. In her job description, she has responsibilities that deal with nutritional programming, supplemental curricular materials, PE guidelines. She recommends budget appropriations. She spends 5% of her job doing a monthly meeting with the Board of Education, and she spends another 10% of her job advising the COO. And one part of whether or not someone is a policymaker deals with what type of advising role they have, and part of that advising is anyone in the stream of communication to the ultimate governing body. So the fact that she also advises the COO as well as the Board of Education gives her a role that has discretion within the district, and she is able to implement policy throughout all 7 schools.
I thought she was having arguments with the board in terms of policies that she wanted to implement. It was the 60 day of exercise a day, and they struck that down. So she must not be a very good policymaker.
Well, Your Honor, just because the board hasn't accepted some of the policies that she's put forward doesn't mean that the disruption in her relationship with the school board renders the fact that she has this policy making, it doesn't make it any less true.
Is there a test out there in the cases that would give us guidance on what a policymaker is?
The policymaker determination tends to be very fact-based. And so a lot of the things that different cases have looked at have been the level of discretion and have been how much influence those people have. So for example, in Pickering, a teacher was found not to have not a policymaking function. However, in a case called Vargas v. Racine United School District, the court found that a principal was, because the principal could control the policy of that entire school.
Does there have to be a nexus between the policymaking status and the free speech? So does she have to be a policymaker as it relates to vaccinations rather than a policymaker as it relates to other activity of the school board?
She does need to be a policymaker as it relates to the speech, at least tangentially, and that is clear in this case.
And going back to Justice Babb's question, then it's very clear on this record that she never made any policy at any time related to vaccines, right? In fact, every time she attempted to change that, she was defeated. So isn't that dispositive on the policymaker as long as there's any sort of connection?
She did not make any impact in the record as to the vaccination issue throughout her position as the coordinator of wellness, but she is connected to the vaccination issue. In fact, she testified at the lower court level that her job was made easier after the op-ed was published because children were asking her about the vaccinations, and she was able to explain vaccinations. So she views, at least in part, her job as connecting to the overall wellness, which does include vaccinations. And additionally, she distributed a memo to the PE and health teachers, which did discuss the immunization change of the tetanus booster shots, which was in part decided with Cindy Cho. And Cindy Cho is the person that is in charge of signing off on religious exemptions. However, her and Cindy Cho both have discussed vaccination policies or vaccination issues that have arisen in the district before. For example, in January 2012, Ms. Pataki recommended sending home all unvaccinated children because one student had measles. And
She lost that one too, right?
she did lose that one.
Well, let me ask you this, though. Getting away from the policymaker, isn't the first question really whether when she was writing this op-ed piece, if she was speaking pursuant to her official duties?
Yes.
And what's your position on that?
We believe that she was speaking pursuant to her professional duties. And that was the threshold question added by the Supreme Court in Garcetti. Just because speech...
Yeah, but how do you reconcile that with Lane? I mean, it seems to me that Lane really narrowed that. I mean, I don't, first of all, I mean, I think that when she certainly didn't identify herself as a wellness coordinator when she wrote the article, and I'm not aware of any job requirement that was introduced into evidence that said that the wellness coordinator, one of their jobs was to publicly speak about issues.
That's true, Your Honor. However, the inquiry into whether it was pursuant to professional duties is not based just on job description. It's based on practicality, and speech does not have to be expressly required to be pursuant to official duties.
But Ms. Davenport, Garcetti was such a different situation. Garcetti involved an internal work memorandum. How in the world can you analogize an internal work memorandum that I believe a deputy prosecutor had done to an op-ed piece that doesn't identify her as being affiliated with the school district? How can the term pursuant to her work description have any definition if those two things are the same?
Sure, Your Honor. So some of the statistics that were used in her op-ed were statistics that she gleaned from her position as a wellness coordinator. Additionally, as we were discussing earlier, she has given out information about immunizations to teachers throughout the district. And in the meeting with the school board in which her employment was terminated, she said, quote, "I'm the wellness coordinator. I care about keeping kids healthy. I had to speak out. I couldn't just sit back and watch." That's on page 55 of the record. So she at least viewed the op-ed as sort of a continuation or an extension of her position. And the test, again, is that the speech owes its existence to the public employee's professional responsibilities.
Shouldn't we be concerned that, under your theory here, that the person who's most qualified to know something about the vaccination policy of a matter of significant public concern is the one who's least able to add to the public conversation about the vaccination policy? Like, you've just made a compelling argument about how she knows what she's doing, and yet here's a person who's not able to express a legitimate concern about the way vaccinations are being done in the city?
Yes, Your Honor, and courts have acknowledged that that is an issue, and they have acknowledged that when someone is in a position to have that type of information, then it does increase the value of their speech. However, courts have not held that just because it increases the value of their speech, that it necessarily outweighs the value and the interest of the government in terminating that employment.
That gets us directly to the Pickering analysis,
Exactly.
right? And if we get to the Pickering analysis, isn't the government interest here very, very weak? Because she wasn't doing anything that was inconsistent with the government policy. She was just suggesting that within the policy, it needed to be applied in a stricter way. Isn't that right?
Well, within the Pickering test, the first question is going to be whether or not she is a policymaker. So we've discussed that before. And if she is a policymaker under the Rose
Let's assume not.
Okay, if she's not a policymaker, then the government still has an interest because of the disruption that was created from the op-ed and its reaction in the community. So several of the factors that this court considers when considering the disruption.
Can I just push on that? Isn't that the wrong standard? The standard isn't the disruption in the community, right? The standard has to be the disruption in the workplace, right?
Absolutely, I'm sorry, I misspoke.
And because otherwise, the disruption in the community is exactly what you want, actually, right? It proved that this was an important part of concern.
Right.
So where in the record does it show that there was any disruption in the workplace that was separate from the political process?
Yeah, so the school board itself fired her because of her disloyalty, of the fact that the school board felt that they could no longer trust her. Additionally, Cindy Cho testified that after the op-ed, she said the op-ed was brutal and that damaged an already tense relationship. That was sort of the tipping point in their relationship. Additionally, there's the issue of the election that was ongoing at the time of the op-ed. And so the time, manner, and place of the speech is something the court considers when it considers whether or not there's enough of a disruption within.
Isn't that, though, entirely consistent with any bad act by anybody who goes against a whistleblower? It seems to me here she revealed that the board's own member wasn't adhering to their own policy, that they were providing a not sufficient justification for excusing themselves from the vaccination. They got caught, the board member got kicked out, and then they retaliated by firing her. Isn't that the exact same facts that you would have in any whistleblower situation?
Well, Your Honor, I'd like to push back. The board was adhering to its policy. The board had a policy that if anyone writes on the vaccination exemption form religion anywhere, that exemption is granted. In some other districts, other districts may require a letter from a religious leader or something, but that is not mandated by law, and the board was sticking to its own policy.
But that almost sounds like, if it wasn't, it almost sounds like it's smoke and mirrors, that they were actually, the policy was you only get an exemption from the law if you have a religious thing. They then interpret it in such a way that almost sounds like wrongdoing that she was revealing in that circumstance, no?
Well, Your Honor, one of the reasons the speech was so disruptive was because it came in the middle of an election. And the timing is particularly suspect because the Slamkowski incident with the measles was something I discussed earlier in this argument that happened in January of 2012. So this is over a year and a half later that Pataki is taking it upon herself to reveal, or not even to reveal, because this is a policy that's well known to parents and students. That's the policy that's outlined in the letters and the forms that students and parents receive.
But in terms of the disruption, I mean, how do you grapple with the fact that when you look at the working unit, the wellness coordinator, the superiors, the folks that reported to her, there was no disruption at all. And so, I mean, I guess I'm struggling with, do we want a wellness coordinator that for whatever reason, you talk about the relationship between the board and the wellness coordinator. Do we want them to have some sort of groupthink and there not to be any tension at all, and her to just be lockstep on whatever they want to do? It seems to me that if this is in this Pickering balancing test, if it's up to the court to weigh all these factors and decide, you also have to address the fact that her core unit, there was no disruption whatsoever.
That's true, Your Honor, but another factor that the court considers when it looks at the disruption caused by the speech is whether it was hostile, insubordinate, or abusive. And Adams, her direct supervisor, although he testified that there was no disruption in their relationship, he also testified that he was surprised that she didn't run it by him first and that he was open to change and willing to help her. And so it's hostile and insubordinate in the fact that there was an opportunity.
I read his testimony too, and he didn't sound like he was that taken aback by it.
That's true, Your Honor, but there were channels that she could have gone through if this was a problem that she had. She could have spoken with David Adams about it before the op-ed. She could have spoken with the board about it before the op-ed, but she didn't. And she that Adams testified, she said to him when he asked her about it, let's not do anything right now, let's wait and see what happens.
Counsel, why are we even talking about whether it was disruptive or not? Isn't that a question of fact that the trial judge was in the best position to determine? Why should an appellate court be second-guessing how disruptive it was?
Your Honor, this was a judgment as a matter of law, so the review is de novo, and we're primarily discussing this because of the circuit split as to how to reconcile the Pickering and Connick and the Branty and Elrod cases. And so within that, under the Rose exception, we're also reviewing the facts de novo. Thank you.
May it please the court. My name is Sam Hoffmeyer, and I represent the Appellee, Marcia Pataki, in this appeal. Looking at this Batson issue, I will discuss and argue 2 points. First, this court should not extend the Batson protections to classifications based on religion. Second, if this court does extend these protections of Batson, they should do so only to protect classifications based on religious affiliation, because these strikes were done because of the religious beliefs, of a particular affiliation. They do not run afoul of Batson. If we look first at this threshold question, whether Batson...
The appellant's argument that this is really a process-based problem rather than a substance-based problem, that the prima facie case was sufficiently made, that there was a discriminatory purpose here, and there was really no explanation. So nothing actually focused on religious belief, but rather everything in the record seemed to focus on religious affiliation.
Your Honor, if we look at the record, we actually do not have any facts or any definitive evidence in the record that all three members were members of the RRC. We have evidence that two of the struck jurors were explicitly members of the RRC. The third struck juror was not stated in the record as explicitly a member. He lived in, that would be juror number, it was Mr. Leismith. He lived in New Emden, but there was no evidence in the record that he was a member of this church. So we can't base it strictly on that. If we look at also the questions from the record.
Is there any real dispute that that's the reason why? I thought you had agreed in the court below that that was the reason for the basis of the peremptory was the RRC affiliation and the religious belief of the RRC. Is that not true? Or?
Your Honor, I think we would agree that the strike was based on the religious belief, but we would dispute somewhat that all the members were affiliated with the RRC, with that distinction between affiliation and belief. If we look at that distinction between affiliation and belief, affiliation is more like the strikes that are allowed, whereas belief is the very essence. Peremptory strikes are required. They're allowed to strike on these beliefs that affect.
Let's say you're correct, right, that there's a distinction between belief and religious affiliation. The fact that your attorney at the time of the voir dire didn't articulate the religious belief as being the basis for the peremptory, but rather came up with some other screwball reason for why they were doing, and then later on you acknowledged that it was religious belief, doesn't that raise the exact problems that Batson are concerned about? It undermines the legitimacy of the court because it appears that the jury is being picked based on a protected class of some sort.
Your Honor, if we look at the prima facie, the burden-shifting procedural requirements, the burden first lies on the challenging party. And even if they meet that burden, the other party then just has to provide some answer, which did happen in this case. Even if we look at the Supreme Court's decision in Johnson, even if this explanation is deemed frivolous or utterly nonsensical, the decision still goes to the court. So the court still then makes the decision whether this strike was based on this unprotected category. In this case, the court did not find that it was. They accepted the non-discriminatory reason of the Ms. Pataki's attorneys, which were based on the 6 substantive questions that were asked of these jurors. These substantive questions went to the beliefs of these jurors, not the religious beliefs, but they did go to the beliefs of the jurors that would impact this fair trial process. So if we look at the purpose and the importance of peremptory the importance of peremptory strikes, that is to create a fair trial and a fair process. If we don't have these peremptory strikes to remove jurors for beliefs, especially when these beliefs have a dramatic impact on the decisions of the particular court, then we do not have a fair trial. If we look at the threshold question of whether Batson should be extended, we look at the Supreme Court's opinions. They have never extended Batson to religious affiliation. They've had opportunities to, and they've never done so. What they have extended Batson to is civil cases in the Edmondson case, and then to classifications based on gender in JEB. These holdings were narrow. They only focused on the explicit classifications in those cases. If we look at the Justice O'Connor's concurring opinion in the JEB case.
What's the purpose of underlying those decisions? What was the policy? Wasn't the policy underlying both JEB and the race cases was a concern that there was a basis of discrimination that undermined the legitimacy of the appearance of the court, whether it was true or not, because there was this perception that they were focusing on a category that just didn't have anything to do with justice. Isn't that right?
Yes, Your Honor, and I think
seems like religion would fit in the same case there. So let's assume for a second that the basis of the peremptory was religious affiliation. If the purpose or the underlying policy behind Batson is focused on the legitimacy of the court, it seems to me you have a similar problem based on a whole bunch of different cases. If what we're really saying is that your participation in one religion versus another is a basis for making you unfit for jury service. Isn't that right?
Your Honor, I think it goes back to the fact that religion is an immutable characteristic. It's somehow different than these other classifications, these other characteristics that we have extended Batson to. We have to look at this idea of discrimination, the Supreme Court has not categorically prohibited discrimination in jury selection. Jury selection is an uncomfortable process, no matter how we spin it. We have to discriminate. We have to distinguish between jurors based on certain categories. What the Supreme Court has prohibited is invidious discrimination based on a certain subset, a certain classifications such as race and gender. Religion has never been extended.
But
even.
What I'm saying is, shouldn't it be? So put aside whether the faith and the belief in the affiliation. Are you saying that being part of a religion just in itself makes you unfit for jury service? If not, then that raises the exact same problem as gender and race as being a basis for. You can then get to whether this is based on the belief or the affiliation, but it seems like it raises the same problem. And isn't the constitutional decisions very clear that you can't discriminate against religion? It certainly can't be a basis for making you unfit for jury service in and of itself, can it?
Your Honor, again, I think we have to look to that immutability idea because religion is.
But let me push it. You're saying because it isn't immutable, then in fact, being part of religion is it a cause? Could you in this case say that it's a cause for? It's not a cause challenge, is it?
No, Your Honor, but I do believe that we could strike a member of the jury for their religious affiliation. That's our opening point. We believe you could strike even for that because religion is different than race. It's different than gender. It's inherently linked with one's beliefs. Even if you're striking based on someone's religious affiliation, that independent affiliation of that juror, it's inherently linked to the beliefs.
How do you square that with the requirement that government and religion has to be at least neutral as it relates to religions?
Your Honor, I think government does have to be neutral, but to be neutral, it can't favor religion or irreligion.
Or disfavor, right?
Correct. Yeah, that is correct, Your Honor. And I think, because religion is a different category, it's a different sort of strike. Again, it's linked to these beliefs. The beliefs that have a dramatic impact, they have this impact on the fair process of the jury trial. And if we're also focused on this competing interest of a fair jury trial. And if we allow strikes based on this, we enter this slippery slope where we can strike based on any belief-based affiliation or any belief-based classification. Someone could be stricken for their occupation because that implies some type of differing beliefs in that occupation.
Let's say we find a Batson violation. What do you think would be an appropriate remedy?
If you find a Batson violation, I think the appropriate remedy would be to remand the case and then rehear the case. But
there's no sort of in between. We're all back. Remand case, new trial.
I think we would have to be if you do find a Batson violation. But again, because I do not believe Batson should extend, I don't think there'd be any way to find a Batson violation in this case.
If we found a Batson violation based on the state of the record, would your answer be different?
Your Honor, I think if you found a Batson violation based on the state of the record, I think that could be a question of law. So you might outright reverse in that case. So then we wouldn't even have the remand. If we look at this immutability idea, the distinction between, the difference between religious classifications and gender and race classifications, religion, again, is changeable. If we look at a Pew Research study, 44% of adults have changed their religion from the time of their birth because religion is inherently linked with one's beliefs, which, again, directly impact this juror's decision-making abilities at trial. We should be allowed to strike based on these religious beliefs.
What authority do you have that immutability is the test for determining whether something should get a Batson protection?
Your Honor, several Supreme Court cases in the equal protection realm have discussed this immutability idea. If we look at the Frontiero v. Richardson case, that was a case discussing gender-based equal protection challenges. They discussed this immutability idea and how these different immutable characteristics are different than non-immutable characteristics.
If we have immutable characteristics that don't get, can you make a Batson challenge based on disability?
No, Your Honor, because there are three factors the court looks at. Immutability is one of those factors, but the other factors involve.
Can you cite me the case that says that immutability is the touchstone for determining Batson?
Your Honor, the Supreme Court has never explicitly stated that. They implicitly imply that in the Batson and the JEB cases. They talk about the difference between gender, the difference between race from other types of classifications, the long history associated with them, the strict scrutiny applied in equal protection claims, and the immutability idea. They talk about that indirectly in both of those cases. If we move on to whether this, if you do decide to extend Batson to religious claims, we look at this distinction again between belief and affiliation. If we look at the facts from the record, again, The record does not definitively indicate that all three struck members of the jury were members of this RRC. We also look to the non-discriminatory reason given by the appellee's attorney in that case. And again, it's a low bar to meet this burden shifting analysis. We only have to, the appellee's attorney only had to give a reason for a non-discriminatory reason, which they did in this case. It was based on
this question. Let's assume that the challenge was based on race. So the three jurors that were peremptory challenged were all of a particular race. And the challenge was then made that this was an impermissible peremptory challenge. And then they provided this excuse, the exact same justification. In a race-based challenge, would this justification on the shifting burden be sufficient and to actually win and say, no, the peremptory is okay?
No, Your Honor. I think if we look at the burden shifting analysis, it's the prima facie case, then the non-discriminatory purpose, and then it goes to the judge.
But you would agree with me, if you look at the whole thing, that us as a reviewing court and what the judge did, if there had been a prima facie case that there had been a peremptory challenge based on race, and then this was the justification, there's no way that we would have upheld this and said that this was a non-discriminatory challenge, right?
Yes, Your Honor, I would agree with that. And that's based on the idea that religion and race are in there.
But if you lose on that, if we disagree, my sense was you were moving to your second argument. And so if you lose and we find, in fact, that we should extend this to the religion categories, then you would agree with me that this justification isn't sufficient to overcome, to offset the prima facie. Because you agree with me that if this was race, this justification, this record, wouldn't hold water at all. We would find this clearly improper, right?
Yes, Your Honor, I would agree with that. If you do decide that, then we would not win the case. So I would concede that point. However, if we're going back to religious affiliation versus religious belief, no circuit has allowed a Batson challenge, a Batson strike, based on religious belief. One circuit has allowed a Batson to be extended, the protections of Batson, to be extended to classifications based on religious affiliation, But again, none, even the three circuit decisions that the appellant cited earlier, none of those allow strikes based on religious belief. This was a strike based on religious belief because of the beliefs of this affiliation. If we take this idea in a more broad understanding of this belief idea, these strikes were based on a small religious organization, the beliefs of this religious organization in the vaccination issue, which was directly relevant to this case. If we look at the record on page 63, the church's views on vaccinations were clear. They were very anti-vaccination. They were strongly against it, and that's the likely reason for the strikes.
If that's true, then why don't we shift the burden? I don't mean in the formal sense, but why don't we just require the attorney to ask that question on voir dire? So if they believe that it's the belief rather than the religion, then why don't they have something in the record that says, what do you think about vaccinations? And they say, I hate vaccinations. Great, get rid of them.
Your Honor, that would be a different case. If we had that, it would be an easier case. But we don't have that in the record, and I do not think that would be necessary to have in the record.
No, that makes perfect sense. But since that's so easy, right? Since it's so easy to say, if you believe there's a belief, right, at least ask them the question, and once you figure out that the belief is there, then why don't we say that the proxy is not sufficient? So your position is that the religion is a sufficient proxy for the belief, and that's perfectly fine. And why don't we just require them to actually make sure they're basing the peremptory on the belief rather than the religion? And as you say, in this record, there's nothing there to show that we can distinguish between the belief and the religion.
Your Honor, if we look again at the basic value of peremptory strikes, peremptory strike, if it's not based on some type of questionable classification, there's no justification necessary at all. So if we look at that value, attorneys have to be able to strike based on gut instincts, based on questions that they ask, based on beliefs that they've answered in these questions to ensure this fair trial. Without that, we would not be able to ensure a fair trial, and we would have this slippery slope where we would lose the value of all peremptory strikes entirely. Again, if we look at those 6 questions, the attorney did have the opportunity to look at the beliefs of these jurors. Although there were other jurors that answered these questions in the exact same fashion, there were only, I've run out of time, may I finish answering this?
Yes.
There were only 3 peremptory strikes available to the attorney. That was all he had available. He likely would have liked to strike all the jurors that answered that question the same way. He only had 3 strikes to use. Thank you.
you, Your Honor. Good evening, and may it please the Court, Ian Bensberg, the appellee on the First Amendment issue. We urge this Court to affirm the holding of the Court below that Ms. Pataki's speech was protected by the First Amendment, and thus that she was impermissibly fired for exercising her First Amendment right for two reasons. First, because she sought to educate the public on a matter of public concern by speaking as a citizen, and that therefore because the Pickering balance weighs heavily in her favor. And second, because this Court has been given no good reason to import a rule of law native to political patronage and freedom of association contexts into this case, which is purely about speech.
Mr. Bensberg, the appellant said that the Pickering test involves a threshold question of whether Ms. Pataki was a policymaker. Do you agree that that's part of the Pickering analysis?
No, Your Honor, I do not agree, and the Supreme Court has explicitly refused to hold that it is. It had that opportunity in Chicago trucking service versus City of O'Hare Trucking Service versus City of Northlake. The court emphasized that the inquiry under Pickering and under Elrod Branty are related though distinct. And Pickering has already been given two substantial threshold inquiries, first in Connick v. Myers and later in Garcetti v. Ceballos, that ensure that once we get to the Pickering balancing, we already have a challenger, we already have a plaintiff who has first of all spoken on a matter of public concern and second of all spoken as a citizen. That's the Garcetti threshold. And so this additional threshold inquiry, it is not necessary to apply it, certainly not as a matter of law, and we don't believe that school board has offered a compelling justification to apply this rule of law. I mean, this court would have to reach the decision to take this rule from the Elrod Branty line of cases and apply it to cases which are purely about speech, as this case is. Even if this court, though, chooses to so do, there is no formulation of the policymaking exemption accepted by any circuit that would permit appellant to prevail here. Because in order to trigger the policymaking exemption, two things are necessary, or one of two things are necessary. First, the employee must have spoken either on a matter of job-related policy, or second, on a matter of politics, and neither one of those showings can be made on this record. But we would urge this court to take a step back from that question, and we would just like to clarify the kind of original basis that was given in Elrod and then in Branty, the logic which underlies that exemption. The underlying rationale for the Elrod-Branty exemption is that some positions require a kind of political or ideological coherence in order for its duties to be effectively performed. So that's why these cases arose in the context of political patronage, because the question is one of, is the employee in a position to thwart the goals, the policy goals of the in-party? And I say in-party because this is again, started out as a political question. Namely, we can assume that, say, a Republican governor has been elected to implement Republican policy choices. If that governor, I'm talking now about Rutan versus Republican Party of Illinois, if then that governor is not allowed to terminate Democratic policy-making staff, then the will of the electorate is kind of thwarted in that sense, because the electorate has decided that it wishes a governor who can implement Republican policy choices, and that would presume.
Does that mean that a government official has to keep employed somebody who's bashing them in the press that's one of their subordinates? Isn't that what essentially happened here?
Well, Your Honor, if that employee is not a policymaking or otherwise confidential employee, then yes, the First Amendment requires that a public.
Isn't that entirely backwards? So if I've got an employee who's the lowest level employee and they keep writing terrible things about the current administration, you're saying the current administration can't let them go?
If it's a question of the lowest level employee, then absolutely not. If one goes back to the Pickering case and reads the letter that Marvin Pickering wrote to his newspaper, it was a virulent attack on the school board members' fiscal policies, whether they cared about the district. I mean, it was serious antagonism shown towards the school board's policies. In this case, and that kind of attack is a logical predicate for any kind of exercise of the policymaking exemption, as Your Honor points out, that the question only arises once the employee has somehow actually attacked her employer, and in this case, there is simply no such actual attack. If one reads Ms. Pataki's op-ed very carefully, it's mostly about...
So let me push on that. If it was an attack, you would say then there was the basis of filing for insubordination because it was putting the current administration in a bad light.
If, Your Honor, it was an attack, And if this court then chose to apply the policymaking exemption, and then further, if the speech were either on politics or job-related policy.
Well, actually, let's say I agree with you on the policymaking exception, or I don't really want to get to it. Can I fire somebody who's insubordinate if they're undermining the particular policy that I'm trying to put forward, regardless of whether they're a policymaker or not?
Well, Your Honor, I guess the question would be then, in what position would this hypothetical employee be to really undermine the positions that the school board is taking? So if we had a
mere fact that they're associated with the administration, so whether they're technically a policymaker or not, if I'm a member of government and all my staff are publicly taking positions saying that the policy's bad and idiotic or whatnot,
yes, Your Honor,
doesn't that make it impossible for me to get my policy? Don't I need new people, or am I stuck with my employees that hate what I'm doing and are undermining what I'm doing publicly?
Well, Your Honor, non-confidential, non-policy-making employees are employees who are precisely not in a position to stymie the implementation of the elected officials' policy goals.
Well, clearly not the case here, right? She stymied it pretty effectively, didn't she?
Your Honor, I would push back against that, and she was not at all in a position. So if we look at her op-ed, what she was doing was urging adherence on the part of district parents to the school district's existing vaccination policy. That is to say, she went through the concept of herd immunity, how important it is for the vaccination to work at all, and then she said, it's time to vaccinate. I mean, that's the title of the op-ed. It was directed solely at district parents. She was urging the parents to comply with the school board's own policy, which is promulgated to district parents in 2007, says that it is the policy of the school board to promote vaccination. Vaccinations are important. We believe them to be important for the health and safety of our school children, and we also offer these two exemptions, medical and religious. If you want a religious exemption, what you have to do is write on the form, I want a religious exemption. All Ms. Pataki was saying in her op-ed was don't abuse those exemptions. If you have no actual religious objection to being vaccinated, then don't avail yourself of the school board's liberality and mislead them and receive a vaccination for improper purposes. That was what the thrust.
So your position is that she was really speaking more in the role of a citizen as opposed to an employee?
Absolutely, Your Honor. If we go to the Garcetti inquiry, which is the second of Pickering's threshold inquiries, if we go to that case, we see that in that case, speech as an employee was defined very narrowly as attorney work product. So when the court in Garcetti said that the speech must owe its existence to the professional responsibilities of the employee, that wasn't some abstract.
Let me tell you this, though. I mean, I consider myself a pretty smart guy. I wouldn't have the knowledge as in my role to go out there and write that article. I don't know all those statistics. I don't have all that information, and so that was my point in asking her the same thing. Is that she gleaned your client gleaned all of this information. She's out there writing a very informed op-ed piece based on information that she has gotten in her professional role as an employee as the wellness coordinator. I mean, isn't that really the difference? I mean, that's not really citizen speech. I mean, anybody could write an op-ed speech as a parent and say some things, but it's not going to read like what she wrote.
Yes, Your Honor. Two things to that. I do not think that is what the court in Garcetti meant when it said owes its existence to the employee's professional responsibilities. Precisely for the reason I think it was Judge Parrish pointed out, the subject matter, that cannot be the test, that the subject matter is somehow related to the employee's.
So your position is one of her ordinary duties is not to speak on this issue or write on this issue.
Precisely.
And that's the test.
That is the test as established in Garcetti. The district, in fact, employs a director of communications who is organizationally unrelated to Pataki's position.
Well, and I agree that's the test, but here's the problem I have on this record, is that her predecessor, Mr. Parrish, was listed on the school board's vaccination policy as the school board's representative on this subject. So it seems to me that I don't know if the record speaks to your client personally, but at least her predecessor had a role that was directly related to this. Isn't that a problem for you?
No, Your Honor, to the extent that there is no evidence, as you mentioned, to the extent that there's no evidence on this record that she filled the same role. The vaccination exemption request forms were directed to Cindy Cho. They were signed by Cindy Cho. When Ms. Pataki had a suggestion. She went to Cindy Cho in order to bring that suggestion. Cindy Cho, as the director of health management for the district, is clearly the kind of public face of this policy, and Marcia Pataki's position is.
Before you run out of time, then let's just, if we could, just fast forward, and we can come back if one of the other judges wants to do so. But let's get to the test then. And so you heard our questions about this sort of disruption. So your position is that there's just no disruption at all, or if there is, it just balances in your favor.
Well, Your Honor, if we're talking now about the Pickering balance, we think that the district court was absolutely correct in saying that this is an easy case, and then saying that the government side of the balance sits nearly empty. So again, for a plaintiff to get to Pickering balancing to begin with, she has to have spoken as a citizen on a matter of public concern.
And you know what? Okay, but one of the problems that I have, though, is that your client almost went a little bit too far and had to make it personal. And we had ultimately one of the school board members that wasn't reelected.
Yes, sir.
And I mean, how could that not create some sort of disruption that's material that we ought to take into account?
For two reasons, Your Honor. First, Pickering itself made clear that the individual interest of the school board members as persons are not to be equated with the interest of the school board as an entity or with the school district as an entity has in efficiently providing public services. I mean, that's the nature of the Pickering balancing test to begin with, is to what extent, if any, did the employee's speech disrupt the public employee's ability to provide public services.
Let me ask you a question. I'm just pushing on that a little bit, and I know it's going back, but I just want to do a hypothetical. Let's assume she says, instead of what she wrote, she does an op-ed and says every single one of the school board are liars, thieves, etc. Terrible stuff. They all get reelected. Do they have to keep her on her staff for the rest of the time then?
Your Honor, I suppose that would depend, at least initially, on the status of the policymaking rule that this court chooses to adopt. If the policymaking rule is not adopted, or if she is not a policymaker, then she is free to do as she so chooses. In that situation, she can take to her blog and say, I really dislike, Stewart, I really dislike Langford. I mean, that.
Well, no question she can do that, but you're also saying that there's no ability at all to be able to remove people that have different views as to the policy of the existing administration.
Well, Your Honor, that's precisely where the policymaking inquiry comes in. If they are not in a position to thwart the implementation of those policies, just as Marvin Pickering, as a teacher, was not in a position to thwart the funding decisions of the school board, he was free to criticize them as virulently as he such short of defamation.
What do you do with the record here that shows that Stewart was not elected as a result of the op-ed?
Well, Your Honor, we would urge against any rule that looks to the effects of the speech, particularly as to determine whether the speech is political speech.
So wait a second. You say the only way you can determine whether there's a policymaker is whether the policymaker has any ability to change policy. And then you say I can't look at the effects of the speech to determine whether they're a policymaker? How does that work?
Well, Your Honor, sorry, if I could just clarify the distinction, I think, between those positions. The inquiry in the policy-making analysis is this position that we're talking about the kind of job on which there's reasonable room for disagreement in an ideological sense or in a party sense. So what the example that the Branty case uses is one of a state university football coach who undoubtedly the court said can be said to make policy in the sense that a football coach is responsible for a staff and can make decisions. But the court went on to say that no one could seriously claim that a football coach that Republicans make better football coaches than Democrats or vice versa. So the question is this position, the type of position, which has as a requirement for its effective performance some measure of political or ideological coherence. And in this case, we're talking about a position that, urges kids to have apples instead of Pop-Tarts for breakfast, tetherball programs and so on. This simply has no ideological or affiliational dimension. I would argue that the same is even true for Cho as director of health for the district. It's a question of medicine and science, and there is no kind of ideological dispute kind of available on those bases. To take the second part of your question earlier about the question of the effect, if the policymaking exemption is applied by this court, I said previously that exemption can only be triggered by either speech relating to job-related policy or politics. And so if the inquiry as to political speech, whether something is political and therefore censurable on the part of the public employer, that would deeply chill any kind of public employee speech to the extent that they would have to be sitting there worrying, well, if I say this, could this possibly have an adverse effect on some election in the future? And we argue that that goes precisely against the policy that was identified by Pickering in having these employees speak. Namely, as Your Honor mentioned earlier, these public employees are precisely ones in a position to be able to comment kind of most helpfully and most educationally on these issues. And it's precisely matters of public concern that are most likely to cause, Your Honor, I see my time is up. May I finish my thought? Thank you very much. Issues of public concern are precisely those most likely to engage the political interest of the citizenry or to have a political impact. And so if we say that if it has sometime in the future an impact on an election, then that's chilling any kind of speech precisely on those matters that the public has the greatest interest in hearing. So for those reasons, we urge affirmation of the lower court's decision. Thank you, Your Honor.
Thank you. The appellant save time for rebuttal?
Yes.
All right, proceed.
May it please the court, the problem here is that the district court tacitly accepted the appellee's reason for the peremptory strikes before the appellee gave that reason. That's the quote in the record that I mentioned earlier about not interpreting the Constitution in a novel direction today. And the problem with that remark is that no extension is required because the language of Batson applies broadly without any distinction between religious belief and religious affiliation, because the line between belief and affiliation, if it can even be drawn, would shift in every single subsequent case. This is what the Seventh Circuit talked about in Heron. It's impossible to distinguish why affiliation should be entitled to more protection than belief. And it's not at all clear why a Jewish member of a veneer could be distinguished based on wearing a yarmulke because he was devout or because he adhered to beliefs of the Jewish faith. Similarly here, it's impossible to distinguish whether these jurors who were dismissed adhered to beliefs of the RRC merely because they lived in New Emden versus whether they were members of the RRC faith. That's an impossible distinction. It's a difficult line to draw, and it's one that we submit courts should not have to be in the position of drawing. And the way to avoid that is to apply Batson, because Batson made plain, as interpreted in JEB, that its language does apply broadly to any classification receiving heightened scrutiny, and religion certainly receives heightened scrutiny.
So can you imagine a situation here on a different factual record where the result would be different than what you're advocating?
In terms of
if there was more information about their beliefs and their affiliation, to try to draw that line, that distinction? Could you ask a set of questions that might make a difference?
Yes, Your Honor. And that question could be what Judge Parrish alluded to earlier. If the question, Ms. Pataki's lawyers in the district court could have simply asked, what do you believe about vaccinations? Do you think that vaccinations are proper? They need not even get to religion, because that would be similar to the death penalty hypothetical.
So the point is that we could decide this case without really having to take a position on what the law should be. We could decide it on the facts and distinguish it, correct?
Precisely, Your Honor. And if this court did that, that's why I'd like to correct something from the appellee's argument. This court need not remand for a new trial, because under McMath, it could, if it chooses to seek that, to occupy that middle ground that you've just mentioned, it could remand for nothing more than an evidentiary hearing. So we certainly submit that it should vacate the judgment, and if it doesn't vacate the judgment, that it should remand for a new trial. But if it doesn't do that, then it should at least remand for an evidentiary hearing. Thank you.
And what happens after that? So evidentiary hearing, we have the shifting burdens, same judge, right?
Correct. Presumably, Your Honor. Presuming that same judge is still on the bench, yes. We would have the same judge.
And you're back up here arguing, so the judge makes the same decision and says, I considered it. I think it wasn't for it was for belief rather than for religion, and then you'd appeal again, right? And we'd be back at the exact same issue that we're on now and deciding whether to extend Batson.
We would appeal again, Your Honor, if the judge made that much of a blanket denial, but we would hope that on remand, the district judge would take a closer look at the facts, would ask the lawyers to conduct the voir dire process differently, and we would hope that that would yield a different result. We respectfully request that this court reverse the judgment below. Thank you.
Your Honors, I would like to correct a contention made by the appellee about the merits of this case. This case is not a case that's purely about speech. The district court found that this case did involve political affiliation, and this op-ed was published 2 months before an election. In that op-ed, it identified that at least 1 of 5 board members held an anti-vaccination belief, and this later became an issue in the campaign. Because of this, this is why both Pickering-Connick and Branty-Elrod lines of cases apply. And because those are distinct case lines, this is why the circuit split exists as to how to reconcile a case in which speech and political affiliation are combined. We are asking that this court adopt the Rose exception, which has been adopted in 4 other circuits. Under that exception, if someone is found to be a policymaker, this is why the policymaking question is the first question that's asked. If someone is a policymaker, then they can be fired if they spoke on something, if their speech touched on a political affiliation or on a policy consideration.
Counsel, can you show us where in the record there was a determination made that this was based on that a political affiliation was involved here?
Your Honor, it's true that this case doesn't involve something as party affiliation as Democrat or Republican. However, the district court judge in his opinion did say that this does involve political affiliation. I can't remember the page number. However, because this does involve political affiliation and speech, this is why the Rose exception applies. And under the Rose exception, if someone is a policymaker, then as a matter of law, the test favors the government, which is why the government is asking, in this case, for the Rose exception to apply, but also asking for a reversal of the district court's lower decision for Pataki.
Can I just ask you a background rule that I'm not sure I understand?
Yes.
Could they have fired Pataki before she did the op-ed? So she seemed like a bit of a troublemaker in the sense that she was having some disputes with Stewart anyway that was long ongoing. If they'd fired her the day before she had written the op-ed, would that have been a legitimate firing?
If they were firing her pursuant to professional duties and it had something to do with actual job performance, then yes, firing her before the op-ed is a legitimate firing. And it's still a legitimate firing to fire her for the op-ed because unlike the characterization by the appellee that this was merely an op-ed that encouraged parents to adhere to the existing policy, this was an op-ed that insinuated that the school board is putting children at a risk by having this policy. And so the hostile, insubordinate insinuation that your school board doesn't have your children's best interest at heart is exactly why the Rose exception acknowledges that affirmative disloyalty, unlike just mere passive political affiliation, is something for which a person can be fired. Thank you.
All right, the court will stand in brief recess.
Thank you all. Please join me in a round of applause for our wonderful competitors. After deliberations will occur, there'll be about 15 minutes, and then you'll be invited to come back to hear how the case turns out. Thank you so much. Thank you all for coming back. We are about to enter into the deliberation portion, and the judges have been doing their own deliberation But they'll come out, they'll give some general comments that will hopefully be helpful to all of us here in the audience, and then they'll announce the winners. So briefly, before we actually get into that, we wanted to let you know who the wonderful panel of judges were. So if you guys would direct your attention to Miss Margot over here, she's one of our executive judge coordinators. And so she'll tell you a little bit about the judges. Thank you so much, and we hope you enjoy.
Hello everyone, thank you for coming tonight. From left to right, we start with Mr. Bryan Babb, Chair of the Appellate Services Group of Bose McKinney Evans in Indianapolis. He graduated from our law school in 1999 after earning his undergraduate degree at the United States Military Academy at West Point. There he was a member of the 1988 football team that beat both Navy and Air Force and played Alabama in the Sun Bowl. Following service as a captain in the Field Artillery with the U.S. Army and an MBA from Boston University, he earned his J.D. cum laude from the law school, where he was editor-in-chief of the Indiana Law Journal and then served as law clerk to Indiana Supreme Court Justice Frank Sullivan, Jr. Next, we have the Honorable Viola Taliaferro, who graduated from our law school in 1977. She was the first African-American magistrate in Monroe County and its first African-American judge. She's an innovator in Indiana juvenile justice initiatives. Judge Taliaferro has been a tireless advocate for Monroe County youth. She was named Judge of the Year by the National Court-Appointed Special Advocate Association and was awarded the Sagamore or the Wabash both in 2004. The law school's Family and Children Mediation Clinic is named in her honor. Next, we have the Honorable Deborah Lynch, appointed U.S. Magistrate Judge on October 24, 2008. Magistrate Judge Lynch was of counsel at the law firm of Taft, Stettinius & Hollister, LLP, from 1988 to the time of her appointment. Magistrate Judge Lynch served as law clerk to the Honorable Sarah Evans Barker from 86 to 88. Judge Lynch is a summa cum laude graduate of the Indiana University School of Law in Indianapolis, where she served as editor-in-chief of the Indiana Law Review, and a magna cum laude graduate of the University of Miami, Florida. Also, we have the Honorable Mary Ellen Diekhoff. Following law school, Judge Diekhoff went into private practice with Harrell, Clenending, & Coyne, and was a deputy prosecutor for 16 years in Monroe County, Indiana. In her role as first deputy prosecuting attorney, she was responsible for most major felony prosecutions. In the fall of 2004, she was elected Monroe County Circuit Judge and presides over Circuit 5, handling criminal cases. She is also the presiding judge of Monroe County Drug Treatment Court, which is in its 15th year. Last, Dean Austen Parrish was named Dean, and James Rudy Professor of Law of the Maurer School of Law on January 1st, 2014. A graduate of Columbia Law School, Dean Parrish served as the Vice Dean and Chief Executive Officer of Southwestern Law School before joining Indiana Law. His scholarly interests include transnational law and the use of domestic law institutions to address global change. Thank you so much.
All rise.
Please have a seat. Darn it. Being here tonight is reason enough to be a judge. This is one of the great perks of the job, and you'll hear this probably more than once that you all do a better job than many of the lawyers that we see in our courts from day after day, and that's not an exaggeration. You're obviously all really well prepared and articulate, and just did a fantastic job. I think we're going to take a couple of minutes and just so that the judges can make some general comments about oral advocacy, and then we'll talk about our winners. What I'd like to say for my part about appellate arguments is that that I think the goal, you've really achieved the most important thing you can as an appellate advocate, is if you can get to a position where you're comfortable enough with the legal framework, with the record, with the facts of the cases that you're discussing, that you can have a conversation with the bench. That's a wonderful thing. And you did pretty well at that with all your nerves and everything. A couple of us really engaged you and challenged you, and you did have a conversation with us, and I think that's terrific. And I think that it helps to be able to step back from the rigors of looking at all the cases and figuring out how the arguments work. Sometimes to step back and run your arguments by somebody who's not involved in the moot court problem, just to get somebody's sense of, well, what do you think about this? Or what would your questions be? Or what sort of policies are at issue here? That's a big deal to talk about the policies behind the arguments that you're making. It also helps prepare you sometimes for sort of offbeat questions from the bench, because sometimes judges ask you strange questions. And if you've been talking to people who are not as mired in the problem as you are, you're more likely to be ready for that and to understand some of the policy issues. And so that those are my general tips and comments. Anybody else?
Sure. I thought it was exceptional. I thought it was just amazing. I thought you guys did an absolutely tremendous job. I thought the forensics were really nicely done, well composed, good pacing. You scanned the bench. You answered the questions directly. My theory on final benches is that you, as a judge, you push a little bit, and the person isn't able to handle it, then you cool off. Otherwise, you go for the jugular. And I thought you guys, I thought you handled it really well. I don't think anybody, I thought it was terrific. My only two suggestions was, I think the hard thing on these arguments before appellate courts is to dig into the policy a little more and weave in the policy into the answers more than just the doctrine. And I thought there was a few places where you could talk a little bit more about what's really going on, what's the reason behind the First Amendment or the policy exception, or what's the reason behind the Batson challenge. But that's just a little quibble. And then I thought a couple of times you could have weaved back into the cases a little bit and transition from your point back to, and here's a case that agreed with that. But those are very minor quibbles. I was very proud to be dean up here today. I thought it was just an exceptional performance, and congratulations and thank you. It made us look good in front of the judges.
I would just echo that. I thought it was excellent. I thought all four of you did really, really well. And you all, your demeanor, the way you addressed the bench, it was exceptional. It was really pleasurable to be here tonight. So thank you, and thank you for all the work that you put into it.
Well, it's clear that you did your homework.
She was a former teacher, so you know.
Well, I've looked around here, and I don't see anyone who was ever in my courtroom when I was doing juvenile court. Because if I see you, I'm coming for you. No, it really, you did an excellent job. You have a lot to read, a lot to understand, and it's clear that you did your homework, meaning you were very sure that you knew what the case was about, and you didn't hesitate one bit. The way you presented it was just excellent. It's been a wonderful experience for us. I want to thank you very much for the things that you've done, and I wish you continued good luck.
It was about 15 years ago when I was one step away from making it to the finals. Not that I'm bitter about it or that I've forgotten about it, but it is important because there will be two winners and two folks will not. But you need to understand that, and I've done moots for this competition, for the other schools, for the one in Indy and for other schools, and by far and away this is absolutely the best. I mean, it just is, and you guys need to understand that. I've seen a lot of oral arguments when I clerked for the Indiana Supreme Court. Saw a lot of oral arguments. I've done a lot since then, and I mean, a lot of times it's lawyers that are super great lawyers and super talented, but maybe the press of other business and stuff like that doesn't let them do their best on that particular day. But I'm telling you right now, it doesn't get any better than this. It really doesn't. One of the things that was, and it came up a couple of times here, it's always so important in appellate law, but the standard of review is everything. It really is. And you guys will figure that out. All arguments are won or lost in the standard of review. And in this particular case, obviously, when you're challenging one, you want to take the position that it is de novo, and you want to make them comfortable for that, because oftentimes when it's not, you're in an uphill battle and you just won't win. I thought that, and one thing that was really good, and something that I pressed one of the speakers on, is that you do want to try to narrow your holding as much as possible. I mean, oftentimes courts, especially state high courts, I mean, they get concerned about not so much this case. I mean, for example, the Indiana Supreme Court, it's a lawmaking body. For the most part, the circuit courts are. They're very rarely reviewed. The U.S. Supreme Court is obviously a lawmaking body. They're not worried. They're not so much worried about the case that's in front of them. They're worried about how that case is going to impact all the cases that follow it. Every now and then they'll correct error. They'll do justice. But for the most part, they're looking for practical rules of law that can be applied in the next case. And so when you have a problem like we had here sometimes on the factual record with respect to the Batson, I mean, you do want to fall back and say, you know what, hey, let's go back. Let's remand. Let's do a redo on the evidence and see if we can come to a different result. If that's the problem, was a process and an amount of evidence here. And so that was a great answer, I thought. When you do these things, and whether it's in front of a trial judge or an appellate judge, you have to have one or two thematic safe harbors. You always have to. And I don't care whether it's an appellate argument or whether it's a trial court argument, you need to be, when I open my oral arguments, I always distill my opening statement is, this is a case about. You ought to be able to distill every legal argument down to a sentence. And it should be that narrow. And then you need to have one or two safe harbors that no matter how hard you get turned around, you're going to always fall back on that. And that's your horse, and you're going to ride it, and you're either going to die or live on it. I talked to a buddy of mine at Baker Daniels who's getting ready to argue at the U.S. Supreme Court in January. And he said really the disorienting thing about that court is, and if you've ever been there, and I'll tell you this right now, this goes for everybody, if you guys, whether it's you practice in Indiana or elsewhere, but in Indiana, you can actually go with the state bar and you can actually be sworn into the U.S. Supreme Court in person as opposed to just having it done on paper. And it was by far and away the most impressive, coolest thing I've ever done as a lawyer. Literally like 5 feet from the justices. And it's really interesting because when you're there, the court is so big that you're literally just getting pounded with questions. In fact, you don't even know who asked you a question because by the time you turn to look at the person, you're being asked another one. But that's where you got to have that. You got to have that thematic safe harbor. You got to keep coming back to it. You practice it in the car. You practice it in the shower. For the last 2 or 3 days going up to it, that's all you think about, so that when you get there, you're comfortable. And you also have to be confident, and was certainly the case with all four of you. Nobody knows this case better than you. Nobody. There's no possible way that those judges, as smart as they are, can know this case as good as me. And then you stand up there and you guys do what you did, which was great. Everybody was conversational. I always am shocked when I go to oral arguments and literally, and this is even some of the best attorneys that I know, they literally just sit there and read. Nobody reads during a conversation. And there's nothing wrong with eventually going back and looking at your notes if you're asked a question, especially about the record. But I thought all of you did a very good job of actually looking at us and having a conversation with. That's what appellate arguments are. At their core, they're conversations. Everybody did great on that. One of the really effective things is that, and I think, and some of you did it and some of you did not, but when you have an answer, if you want to get out 2 or 3 things, it's very important to say, and I have 2 answers to that. One of the best law students that I ever met when I was here and then when he practiced was a guy by the name of Matt Gutwein. And Gutwein, every single time I saw him in moot court and also when he practiced and argued cases, I mean, he probably said that 10 or 15 times during an argument. I have 2 responses to that, Your Honor. But you know what? When you tell the judges that, they'll actually, most of them, will let you get that out. And in fact, if you do it to the Indiana Supreme Court usually, they'll literally sit there and say, okay, let's hear them. And they'll write them down. And that's important because you may never get to 1, 2, you may never get to 2 or 3. You may get to 1 and then get derailed on something else, but at least you've gotten that point out. But all of you did great. You did excellent. You're all going to be fantastic lawyers when you leave here. And this is for all the other people that are in the audience. I mean, it is a great privilege to practice law. It really is. I mean, I was in the Army for about 5 years before I went to law school. And I can tell you that, for 15 years now, I've probably woken up and maybe 5 times said, you know what, I wish I wasn't a lawyer. It's an awesome job. I mean, it's mentally stimulating. It's exciting. To practice in this state, and most states and most areas, is great because everybody's usually professional and very nice. And you guys are going to be great. And everybody that has a chance and the privilege to go to this law school will do great because it is a fantastic law school with a great reputation, and not all of them are like that. So think about that when you're still paying your bills like I am. That's all, Your Honor.
All right. After deliberations, the court has determined, and as you know, the court is choosing a winner by issue. On the Batson issue, the court has determined that Mr. Hoffmeyer is the winner, and on the First Amendment issue, the court has determined that Mr. Bensberg is the winner.